All right, thank you all very much. And again, congratulations to the research and the papers presented we had. And again, just to reiterate what David suggested, and hopefully if free alcohol isn't enough to entice you to come to the reception tonight, certainly the paper presentations, the poster presentations will, and we're looking forward to that as well. So we're going to switch over now to talking about the growing role of litigation for government transparency. And we've talked a lot about the litigation, and anyone who follows the separation of powers out there knows that the impact of litigation and a lawsuit has as much impact on public policy as any law that comes out of the legislature and the executive order that comes out of the executive branch. So certainly we appreciate the importance that litigation plays in keeping these public institutions accountable and transparent here. We're gonna look at that, and as David pointed out, the growing investment from philanthropies into the number of law clinics that are popping up around the country that we're seeing, and the more investments going on to increase this litigation role both at the federal and the state and local level continues to increase, and we're going to explore that today. And at the same time, we're seeing some not so good things happening, where we're seeing some of these public institutions turning around and through some of the third-party litigations or some of the revenge lawsuits that we've talked about and seen out there. In Colorado, we had a case as well that Jeff's group worked with on an agency that sued a public records petitioner. So we're going to look into that further here in this discussion here. We have just a wonderful group of presenters up here. You've met most of them all, and Judge Ho is going to introduce the panel. We've got a couple of Hall of Fame. Hello? Okay. All right, we've got a couple Hall of Famers that are up here as well. Let me just, like I said, you've got the bios in your programs, but I just wanted to mention just a couple other things. It's always great to have public officials who are very active and supportive in the FOI area, whether they're from the legislative or executive or judicial branches. And Judge Ho, we're really pleased to have you here today. I just wanted to add that, prior to taking the bench here in the 5th District, that Judge Ho has been a vigorous champion of open government. He's chief counsel, he was chief counsel to Senator John Cornyn, and played a critical role in drafting the Open Government Act here. And then also as a litigator, he successfully defended the Texas Open Meetings Act against constitutional attack, first in Wrangler versus Brown, and again in Gerson versus Abbott. And he's also written numerous articles in support of stronger open government laws. So, this is certainly a fan of ours, and we're glad to have you here. Judge, I'll turn it over to you.
All right. Not sure how I should hold this. Can you hear me? There we go. Well, thank you so much for the very kind introduction. I am genuinely honored and excited to moderate today's panel. And that's because, on a number of occasions over the years, I've been very lucky to have various opportunities to get to learn from federal and state open government experts. And I've always tried to take advantage of those opportunities. I think you alluded to them earlier. I tried to take advantage of that when I was on Capitol Hill, working for Senator Cornyn on open government FOIA reform legislation. Did so at the Texas Solicitor General's office, litigating various cases about Texas public records and open meeting laws. And I'm delighted to be able to have that opportunity to do that again today. So our panel today is going to focus on some recent trends in FOIA litigation across the country, as well as some of the legislative efforts that are percolating to redress various concerns that may have arisen in this area. And to do so, we have a wonderful panel of experts to guide this discussion. I'm going to let them talk. They're the experts. I'm going to set myself aside a moment. But each of our experts has agreed to speak for about 10 to 15 minutes each, and then we'll hopefully that'll leave plenty of time for some questions. First is my good friend Laura Prather. She is head of the Media Law Practice Group at Haynes & Boone in Austin, Texas. She's a longtime advocate of open government before the Texas legislature. She was instrumental in the passage of the 3 most significant pieces of First Amendment legislation in recent history in the state of Texas: the Reporter's Privilege, the Texas Citizens Participation Act, and the Defamation Mitigation Act. She was named by the American Lawyer as one of the 45 best young women lawyers in the entire country for her substantial expertise and experience in First Amendment and media law. And she's also been ranked in Chambers USA as a leading expert nationwide in First Amendment litigation. Terry Mutchler is managing partner of the Mutchler Lyons firm in Pennsylvania. She is an experienced trial attorney and previously an award-winning journalist. She was appointed by Pennsylvania Governor Ed Rendell to create and found Pennsylvania's Office of Open Records, serving for 7 years as the founding executive director of that office. And before becoming an attorney, she was an investigative reporter for the Associated Press, becoming the first woman to be appointed AP bureau chief and State House correspondent in Springfield, Illinois. She's also served as AP bureau chief in Atlantic City, New Jersey, and Juneau, Alaska. I wonder if there's a trend there or something. Is there a pattern, Illinois and New Jersey and Alaska? Before that, she was a reporter in Pennsylvania and won several Keystone Awards, which is Pennsylvania's top honor for reporting. And last but certainly not least is Frank LoMonte. LoMonte, a professor of media law, executive director of the Brechner Center for Freedom of Information at the University of Florida, which is a think tank that publishes practical scholarship about contemporary issues in the law of access. He previously practiced law with the Atlanta office of Sutherland LLP and clerked on the 11th Circuit. Before joining the faculty at the University of Florida, he served for 9 years as the executive director of the Student Press Law Center in Washington, D.C. As the founder of my high school newspaper many years ago, that's a particularly fond resume point for you. He has also taught at the University of Georgia Law School as a distinguished visiting professor of law. And at Florida, he is the founder and co-director of Fresh Take Florida, which is a news service founded in 2019 to send students to cover news at the Florida Capitol. So Laura, would you like to kick us off?
I'd be happy to. Thank you, Judge. So I'm going to start out with discussion on a good example of litigation that worked, and then move into some not so good, and then into kind of the way it's supposed to work. So is anyone here from ESPN? No? Okay. The case that I wanted to talk about first is one involving an ESPN reporter. And her name is Paula Levine, and she, in 2015, submitted a PIA request to Michigan State University. And she was looking to discover members of the football and basketball team who had been involved with some sort of criminal acts. She wanted the public safety records. MSU denied the request. ESPN decided to sue. This was an instance where they felt very confident that the information was subject to the Public Information Act, and the trial court ruled in in ESPN's favor. MSU appealed. Trial court's decision was affirmed. ESPN recovered $70,000 in legal fees. So that's if you are in a position where you have to litigate, that's the way it's supposed to work. But that's not the end of the story. In 2016, after getting the records, ESPN did a report, and then subsequently, there were several football players that began to be investigated for rape. Paula sent another FOIA request to MSU asking for all of the public safety reports containing allegations of criminal sexual assault for a very specified period of time, including that time period in which the alleged rape happened. Not only did MSU deny the request, this time they went ahead and took it one step further and filed a declaratory judgment action. This is what we keep hearing about: very aggressive governmental entities taking a proactive stance and filing a declaratory judgment complaint against the requester. ESPN, outraged, told their lawyers, full speed ahead. They fired a counterclaim under FOIA, and the decision that was issued by the trial court has some really nice language in it. I'm just going to read a paragraph of it, but it's pretty telling. It says, as is not entirely uncommon under FOIA, the public body denied the request. That denial sparked a sequence of events that is different from those that normally occur in conjunction with a FOIA request. That is, rather than the requester initiating an action against the public body began the instant proceedings by filing an action against the requester. According to MSU, it is unsure whether it can disclose the records that are sought, and it seeks this court's guidance on the matter by way of a request for declaratory relief. MSU contends that its sue the requester approach is justified by the uncertainty it faces. Now, let's just ignore the prior request, right, that they got poured out on. Because this court concludes that the plain language of FOIA does not provide a public body with a cause of action against a requester, the court concludes that ESPN is entitled to summary disposition. That's great, but the other issue that the court addressed was the chilling effect. And the court very specifically said that it agreed with ESPN that there could be a chilling effect that could arise by a public body being permitted to sue a requester under FOIA. The judge said it does not take much imagination to think that the type of suit MSU wants to bring in the instant case could dissuade persons from making FOIA requests in the first instance, out of fear of being sued by the public body. Such a chilling effect would be entirely incongruous with the statutory purpose and disclosure and open governance. That is a wonderful decision. The only problem is the underlying suit is one of many where governmental bodies are taking the initiative and suing the requester for declaratory judgment. Now, my fellow panelists are going to talk about that more, but I wanted to start the discussion at least with a good decision. And now I'm going to talk about Texas. So, in Texas, we seem most recently to be reacting to bad court decisions, and reacting to bad court decisions through the legislature. So we've had a series of really horrible court decisions that have severely compromised the integrity of our Public Information Act. Some of those have been referenced in the prior panel. Chip mentioned them, Amy talked about them, Kelly's talked about them, but one is the Boeing versus Paxton ruling, which is something that was handed down by the Texas Supreme Court in 2015, and it basically cuts off access for taxpayers to find out how their money is being spent. It has been extended to ridiculous proportions. All a third party who contracts with the government has to do now is say, I have competitors. They don't even have to identify their competitors. They just have to say, I have competitors. Well, I have competitors. You have competitors. Everybody has competitors. But if they say that, then the Attorney General says, okay, under Boeing, you don't have to disclose the information. You don't have to disclose how much money or even the various criteria under which you've received these funds to the taxpayer requester who is asking for this information. So Judge Hope mentioned in his introduction very graciously about the various First Amendment legislation that we've been successful in passing here in Texas. And that's been wonderful. But I can tell you it is easier to get First Amendment legislation passed, far easier than to get transparency legislation passed. The opponents to transparency legislation come out of the woodworks. And last session, we tried to fix this Boeing decision, and the wall of opposition was enormous. So this session, we have thankfully been able to work really hard during the interim. We've been working with champions of open government, including Senator Watson and Representative Capriglione, who have been tireless in their support to fix this problem. And I'm pleased to say that SB 943 and HB 2189 are both moving in the legislature. We don't have Gary Elkins there anymore, who is chair of the Government Transparency and Operations Committee, who last session refused to give us a hearing on any of our open government bills. We have a very friendly House State Affairs chairman. Chairman Thielen is very much in favor of open government, and so the climate has changed tremendously. So those two bills, companions, that have been introduced to address the Boeing litigation are moving. So that's great. Then we have another bad litigation story leading to legislation, and that's the Paxton versus City of Dallas decision. That's one that said dates of birth in Texas that are found in public records are no longer accessible to the general public. So good luck verifying that you're talking about the right person, because it's virtually impossible to do that now. This is another one that we decided to try to get fixed last session and did not. But again, this session, things are looking much better. And this bill has been introduced in a couple of different ways. We've got Todd Hunter, Representative Todd Hunter, who carried it last session and this session, and it's HB 1655. And then we've got new Senator Nathan Johnson from the Dallas area, who's carrying it in the Senate, SB 1318. And it has received positive hearings in both chambers. In the House, it is set to go on the floor hopefully next week. So that's moving, and that's great. Then another bad court decision, City of El Paso versus Abbott. This is one that exposed what we call the custodian loophole. That's the situation where you have a government official conducting government business on their private device, but the public information officer cannot reach that device because it was not issued by the governmental entity. So there's this nice little loophole in the law that basically says because the public information officer can't reach the device, even though what's on this device is clearly subject to the Public Information Act, you can't get it. So Chief Justice Jeff Rose wrote in this opinion, this is something that the legislature has got to fix. And that too is moving through both chambers. It's moving through the House in HB 1700 and through the Senate in an omnibus bill that was filed, it's SB 944 by Senator Watson. So it's moving in two different ways. Then last, Hartman Newspapers is a local community-owned newspaper that is basically, or family-owned newspaper, my husband's family, so I should be able to get that right. Anyway, what they did was they requested the front page of an offense report. There had been some talk about a potential bribe amongst local officials, and they understood that this had been reported to the police, that there was an offense report that had the information. They requested the offense report, and they were told no. Now, the front page of an offense report is absolutely open to the public, has been forever, but they were told no. They had to file a lawsuit to get the front page of the offense report. After they filed the lawsuit, then they received the offense report. Problem is, at that point, they had spent however much money in fees, and under our public information law, you have to substantially prevail in order to get your fees. Well, unfortunately, the courts have determined that if the governmental entity voluntarily hands over that information to you, even if it's on the eve of trial, you have not substantially prevailed. So we have another bill this session to address how to define substantially prevail. That is being carried by Representative Smithy, and it's HB 3457. It received a positive hearing last week in the House committee. So all of these are examples of how really bad court decisions lead to what we hope to be legislative reform. The last thing I want to tell you about is a phenomenal instance of where this has worked. And that is the state of Texas versus Doyle decision, which is the decision that was handed down on February 27th of this year, declaring the walking quorum provision under our Open Meetings Act unconstitutional. Now, okay, normally you'd say, that's not great news. What are you talking about? No, what's great about it is it was handed down on February 27th. Bill filing deadline, March 8th. We immediately got a bill drafted. Senator Watson carried it, dropped it before the March 8th deadline. It has sailed through. Senator Betancourt joined as a joint author, passed out of the Senate on April 9th, was referred to House Committee today. It's referred to the House State Affairs Committee, and the House State Affairs Committee chairman is carrying the companion bill in the House. So we feel really good about that, seeing as how 6 weeks after the decision was handed down, we're looking at very, very likely legislative reform. And that's all I've got.
Thank you, Laura. Terry?
It's quite clear to see why Laura is the Hall of Fame winner this year in advocacy. The microphone. I'm going to talk to you today about litigation, of course, why it's necessary, but primarily how to save you money in the litigation angle of this. But to give an overall thread of just a little bit of history about why, but also to tell you what I view as litigation being a tool to get us to what my primary life's work is unified legislation around the country at the state level, so that you don't hear stories like this versus Pennsylvania, for example, where attorneys just got $200,000 in attorney's fees from the government in a bad faith case. So I do think that as we talk today about litigation, and yes, litigation is necessary, but it's certainly not the only sort of tool in the toolbox there. But if we're going to use it, my purpose in speaking to you today is so that we can set it up to use it correctly to advance the law. What's interesting to me is a couple of different things. First of all, I always like to start these speeches by talking to people about how raw sugar, coconuts, and rubber are actually the reasons that we're here today for the Freedom of Information Act. Because in the 1960s, there was a maritime lawyer that wanted to stop in the Mariana Islands, and he filed the proper tariffs with the Maritime Commission. And the general counsel of that commission said, no, you can't do it, and no, the decision behind it is not public. You can't get a copy of my legal decision. Keep in mind, it was a state, federal, it was a government employee on government time, but they said that this decision was not available to him. So what that lawyer did, he was in D.C., he had represented the Pacific Far East lines. He did two things. He filed suit, and he was able to obtain a copy of the decision that said he couldn't stop in the Mariana Islands, or his client couldn't. And the second thing he did is he went to the American Bar Association and said, we need to have some legislation in place so that this doesn't happen again. Interestingly enough, that was sort of the seeds that brought FOIA to the forefront, and as you guys all know, it was, President Johnson signed the act in the 60s. Now, I think that we need FOIA litigation around the country, but we need to be smart about it. And I think that what's happening, unfortunately, is that you see a buckshot approach to litigation around the country that results in horrible decisions, sometimes great decisions, but at the end of the day, it doesn't advance the ball. So what you have is, as one of the earlier presenters talked about these different universes of FOIA, what you have is you have lots of people, over here in one corner advancing, litigation that's successful, and directly and opposite to another corner, that's doing the same types of work, but they're not connected. I believe that there needs to be a unified central place that we can come together so that we can advance the strength of the laws related to this through litigation as one tool of it, in addition to the lobbying and what occurs there. We had a case in Pennsylvania in which It was a pornography ring, and that pornography ring among government officials brought down 2 chief justices of the Pennsylvania Supreme Court, the head of the Department of Environmental Protection, high officials at the Attorney General's office, as well as in the state police. One of the news organizations there filed a right-to-know law request to obtain the information related to this. But when the request was written, the way in which they asked for the material was they asked for all emails, all personal emails of these individuals, even though they were on government computers. Now, in some instances, and by the way, pornography does not describe what was going on here. The old GM ad, it's not your father's, GM. Well, this was not your father's pornography, I assure you. I saw it myself. However, even though in some instances, public officials were spending 6 to 8 hours a day on pornographic websites, this was not obtainable, the court said. We lost this 6-1, by the way, because the way the request was written, it asked for the personal emails of these individuals, even though they were on government computers. Here's where you come in, and here's where you save money. The way in which litigation gets set up starts with the reporter and the request. As the head of the Office of Open Records, I handled 15,000 appeals to the Office of Open Records. Every single time, and I am not saying 99%, I'm telling you, every single time a reporter filed a request and was denied, it was based on the way the request was written. And so while we have these tools of litigation, of lobbying, of the academic research that we all need to do, of course, in this unified way, it all really starts with the request. And the way that the request is written at the beginning is going to set the stage for the facts in litigation as you move forward. I'm a strong proponent of the litigation. I think that we need it. It also pays my mortgage. However, I think that we need to be smarter about this around the country and not use a buckshot approach to it. We need to be saying no to some cases and giving up the battle to win the war in some situations. There needs to be a strategic approach to it. And I think that NFOIC is the kind of perfect unifier to be the hub for each of these states so that we can advance this together. And I'm sure we'll have more of a discussion about this. I just kind of wanted to lay that groundwork. One other component in closing is that one of the presenters talked earlier about ProPublica. I represent ProPublica, and one of the things that ProPublica does best, both from a litigation, a FOIA, and a funding standpoint, is they go back to basics. And that's what every person in this room that cares about FOIA and right-to-know law around the country needs to do. Sit down at the beginning of the year and have a strategic approach to what records you're going to be going for, how you're going to be doing that. Spend as much time on writing the request as you would if you were an attorney, writing the litigation, because it's all going to come back to that. And, you go back to the basics, and once you have those basics, that's what enables the funding to go from $10 million a year in foundation funding to $53 million. Because then you have not just anecdotal stories, you have statistical, demonstrable stories that say, here's what we did, and if we had X amount of dollars more, here's what else we could do. So as we begin to discuss all of this, I'm sure we'll have more discussion about it, but that's my goal is unified legislation and smart litigation that gets that advanced. Thank you.
Thank you. I'm the non-Hall of Famer on the panel. This is like Craig Counsell batting cleanup behind Willie Mays and Hank Aaron, so I'll take my mightiest swing. I thought I would just kind of hop around a little bit and hit some subjects, mostly following up on Laura's excellent comments about what I see out there from my 30,000-foot perch as to some of the trends and the risk factors that are going on in the courts and the legislatures around the country. And Laura, in mentioning the reference about the date of birth issue, and legislators becoming increasingly protective of that, I think put her finger on one of the most important trends that we in the FOI community have to be watchful for, and things that we have to think about in our messaging and in our litigation and our lobbying strategy, which is that we're at this moment in our society of sort of existential privacy panic right now. And just like when Chip and Amy wrote their paper about Amazon being able to conceal the bids that city governments were throwing at them on the grounds of promoting economic development. Those of you who work with legislators know if you label something as an economic development bill, you can get people to drink raw sewage. I mean, they'll just do it if it says economic development on the side of it. And the same is increasingly true of privacy. If you label something as a pro-privacy measure, there's almost nothing that legislators or judges these days, present company excluded judge, will not buy into on the grounds that it advances personal privacy. I'll tell you a quick story about this. I had a student, undergrad student, talk to me about a research project that she wanted to work on. And the research project was, she said, I was really alarmed to find out that you could go down to the county courthouse, and if you know somebody's name, you can find out whether they're registered to vote and whether they voted in the last election or not. And that seems like a horrible invasion of privacy to me. And we should amend the law and fix that. We should get that fixed so that this is no longer a matter of public record. I think if you went around to the public today and you polled them about, you said, I'm getting ready to start a new company, and this new company, this new business venture I've come up with will gather the names and addresses and telephone numbers of everyone in our community in alphabetical order and put them into a book, and that book will be placed on the doorstep of everybody in the community. You'd be tarred, feathered, and run out of that community as a person who disrespects personal privacy. And that's where we are right now, is that we're not having a good quality national dialogue about what are real privacy risks versus phantom privacy risks, and we're legislating and at times making judicial decisions around the latter, around the phantom privacy risk. And nowhere is that more true than in the realm of education, which is sort of my specialty area. Many of you, I talked to Mike about the John Krakauer case in Montana. If there's time, we talk about that one too. It's going on for 5 years now against the University of Montana. Thank goodness John Krakauer, the author, has the resources to litigate a case for records like that. Most of us do not. But there are no fewer than 4 different cases right now in front of different state Supreme Courts around the country that are going to tell us quite a lot in the coming year or two about what the boundaries are of where the right to information ends and the right of student privacy begins. And there is a constant tug of war and tension between student privacy, what many of you know of as FERPA, the Federal Student Privacy Law on one hand, and State Freedom of Information Law on the other hand. And I'm just going to real quick give you a squib on each of these, but I'm happy to follow up with you further if you'd like copies of any of these. In North Carolina, there's a DTH versus Folt is the name of the case. In North Carolina, the Supreme Court is getting ready to decide whether the outcomes of disciplinary hearings at public universities where someone is found responsible for having committed a violent sex crime, whether those outcomes are or are not a matter of confidential student privacy. In Transparent GMU versus George Mason, this is one that involves records of university foundations that are held by nominally private entities, but which are in fact in all but structure, all but formality and extension of their affiliated public university. That's before the Virginia Supreme Court. Colonel Press versus University of Kentucky. This is in the Kentucky Supreme Court. The Kentucky Supreme Court will be deciding whether a university can withhold the records of how it dealt with faculty against student sexual harassment on the grounds that because students are involved as the victims of the sexual harassment, those records of the misbehavior by the faculty can be concealed on the grounds of FERPA student privacy. And finally, Central Dauphin School District, DAUPHIN, this is in Terry's neck of the woods versus Hawkins. The Pennsylvania Supreme Court will be deciding whether video of an altercation aboard a school bus in which a student got into a physical altercation with a parent volunteer, whether that videotape, which is a newsworthy video, can be withheld from the public on the grounds that FERPA student privacy extends to a videotape of a newsworthy event taking place aboard a school bus. So we're about to get some clarification from these state Supreme Courts, and I'm not completely sanguine that all of these are going to come out in favor of transparency, which points us to where we need a better legislative strategy to go to Congress and to get that desperately broken and dysfunctional federal privacy law fixed, because it's denying the public access to information that Congress never intended to safeguard as a confidential student record. By the same token, we're seeing privacy weaponized by law enforcement agencies too, to conceal information about law enforcement officers, the kind of information that I think all of us believe ought to be transparently disclosed. And the best illustration I could give you there, this is in Overland Park, Kansas, a suburb of Kansas City, just this far over the border in Kansas. In Overland Park, Kansas, a 17-year-old John Albers was shot to death by the police in a tragic one of these welfare checks gone wrong, where the police come to the house. It's a young man who's got some mental illness problems. They come to check on him, and this escalates into a fatal shooting, 16 bullets into him as he's backing his car out of the driveway. This is in January of 2018. We're sitting here now in April of 2019, and many of the documents surrounding this case and how the police investigated the shooting have been concealed on the grounds of officer privacy. The law enforcement agency is claiming that they cannot release a document, even the document that was relied upon by the state's attorney in choosing not to bring criminal charges against the officer on the grounds that it was a justified shooting. The document, the report by police that the district attorney used to reach that conclusion is regarded under Kansas law, at least as it's being interpreted there, as a private confidential document to protect the privacy of the officer who pulled the trigger. That is now the subject of a lawsuit that was just filed in March in Johnson County, Kansas, so we'll see what comes out of that. But the law does not clearly entitle the public, as it should, clearly entitle the public to that document, which would shed light on why the district attorney decided not to bring criminal charges against the person who emptied his gun into this young man who was doing nothing more than backing his car out of the driveway. So we have to, I think, engage with the folks who work on the privacy side of the aisle and have a better quality dialogue about trying to reach some rapprochement here about where the boundaries of personal privacy ought to be drawn and what are the sorts of things that the public has an indisputable right to know about. I just want to flag one more thing and then turn it over. You mentioned the Boeing issue, and that came up in Amy and Chip's panel as well. I just want to flag, because this is something that we need to be watchful for. I am seeing government agencies now try to claim that they too can create and hold trade secrets, and that they too can conceal information on the grounds that it has economic value. The University of Connecticut actually won this argument in a case that involved records of their foundation's fundraising efforts. They were successful in convincing a judge that our list of donors to a university foundation could be withheld as a trade secret because that list could be monetized by other people who would like to fundraise. So this is a really aggressive conception of what a trade secret entails, and the idea that a public entity could weaponize trade secrets as a way of withholding public records, I think, is way beyond what legislators had in mind when they codified trade secrets, which was to protect the competitiveness of private business enterprises, certainly not of monopoly state government agencies. And so with that, let me turn it over and invite your questions.
Questions?
I just want to make a point before we get to questions about your piece about that university foundation. It's why it's really important with legislation that the legislation itself is strong. In Pennsylvania, we have legislation that says that records of private corporations are reachable when there's a government contract. And in a case similar to what he's talking about is East Stroudsburg University, an official was trading sex for scholarships. When the reporter filed the right to know law request to obtain the emails surrounding this, the university moved those records to the private foundation. That case came to us at the Office of Open Records at the very beginning of the Office of Open Records, and what we argued and won was that that foundation was performing a governmental function, and therefore that governmental function made private corporate records releasable. But the only way that we were able to argue that was because governmental function was language in the legislation. And so somebody earlier on a panel mentioned that we get into these philosophical thoughts about, how, press freedom and First Amendment, all good stuff. But you got to bring it down to the gut check level. When people hear, oh, wait a minute, you're going to tell me that the public's not going to get to know who this, university official was that was trading sex for scholarship and what that looked like. When you put that on it, then of course you get a different support in the legislature. So that foundational stuff it's critical, and that's why we all have a role, and we all need to unify in doing it.
Okay. What would be the privacy boundaries if someone has applied for admission to the university and they put in that admission request, and then the parents are indicted for these two coming for trying to apply college admission?
This is a hypothetical, right?
I'm laughing because I'm quoted in this morning's USA Today on that. USA Today asked me that question yesterday. So the answer is, and this is where, right, the privacy statute does not at all align with the historic tradition of the common law of privacy, right? Under the common law of privacy, that is an easy question. Under the common law of privacy, when you become drawn into a matter of public controversy, or when you yourself seek to obtain public attention, right, as at least one of the students in this not so hypothetical situation has, right? She's got this enormous social media following that she has monetized for this sort of modeling or acting or endorser career. So when you do one of those two things, either you yourself seek the limelight or you are drawn into the limelight, perhaps by virtue of being associated with a famous person, your common law of privacy is waived. That is not the way the federal government has interpreted FERPA privacy. They have interpreted FERPA privacy to be waivable by nothing less than a contractually binding written agreement. And so you could be the Heisman Trophy winning quarterback of a football team whose face has been on Sports Illustrated and who has appeared on primetime national television, and you have exactly as much protected privacy as an 8-year-old does. And that's why that statute, among other reasons, is so desperately broken. It's a one-size-fits-none statute.
Right. The University of Kentucky case and the student newspaper, the Kernel. So the university sued the student newspaper because...
Another reverse FOI, yeah.
Right.
Reverse FOI.
The university didn't want to release the records that explain how they disciplined a professor for sexual misconduct with a student. And the university has argued vigorously that they do not want to jeopardize the privacy of the student victims. I live in Kentucky, and I hear divided opinion on this. Many people say, oh yes, we have to protect the student victims. And others, believe, well, the university is using this as a ploy to not have to reveal something terrible about a professor. I'm wondering, just everyone really, how you think this discussion that we've had today about being more strategic and working together, what we can do to get people to think about what are the real privacy issues and what are the ones that might be used to just kind of shoo people away who are trying to get records for legitimate reasons.
Well, I'll start, but I'm happy to yield to other ideas. So, two things. First, I think one reason that we're not overwhelmingly winning this argument right now is that the folks seeking concealment, and this has happened both in the Kentucky case and also in the North Carolina case I mentioned, have been able to position themselves on the angelic side of victim privacy. And indeed, in both North Carolina and Kentucky, they actually got victim rights organizations to file supporting briefs on their side saying that this is about the privacy of victims. And importantly, everyone involved in both of those cases has agreed to take the records with victim identifying information redacted from it. So this should not be an all or nothing matter. It should not be a matter that the right amount of production is 0, but that is the amount that these institutions have produced to date. So I think they are in the wrong to at least some degree, and then we can quibble over how much. But the right amount of production can't possibly be 0. But I think this is back to the messaging and storytelling work, which is what I've tried to sort of take on in my still new role here, is it is beyond dispute. I mean, decades worth of factual experience tells us that when you publicize one of these cases, it causes more people to come forward. This has always been the case. You need say nothing more than the words Bill Cosby to know that, right? As soon as people realize that the courts or that the regulatory authorities have their teeth into somebody, then they feel safe coming forward. It's, oh, I wasn't going to be the first to come forward, but me too, right? Me too. It happened there. And so I think we need to tell that counter story better, that no University of Kentucky, by concealing these cases, you are making it much less likely that victims will come forward, not more likely. So we need to get better at telling that story. The other thing is, this is a big picture priority for me, and I'm happy to work with everybody in the room on it, is government agencies need to start thinking about how to create their records from birth, from the cradle, with an idea that I am creating a public disclosure version of this record, right? Which is to say, if they want to create a version that's the unredacted, let it all hang out version, they're welcome to do that, but they need to be thinking about, how can I create the maximum disclosure version of this record? So a sexual harassment complaint would be a perfect example. I need to create one that is a generic one, that gives enough information that the public can tell, are we diligently investigating and punishing sexual harassment, or are we not? And whatever that looks like needs to be a standardized template across all 50 states.
Oh, no, go ahead.
Terry, I want to go back to the comment that you made in your presentation. You mentioned that it was 100% of those record denials were based on the writing. Is that all across the board? That includes journalists as well?
It was solely journalists.
Okay.
So it was, yeah, it was.
So my question is, you can go to so many different websites, journalism websites, and press association websites, and you can click on tips or writing your public record requests. What's going on out there to, we can relook at the instructions and the wording and everything else, because, it's not hard to find instructions on how to file a public record request.
I think that, the answer to that is you're right. You can't, there's a million different forms. Anybody that uses a form right to know law request, and I'm just going to say it, is lazy. And they're not thinking about what it is that they really want. You can't imagine the number of hours at ProPublica that we sit down and actually have the reporter try to talk us through. Just forget what it's written, tell us what you want, and how difficult it is to articulate what it is that you really want, okay? The key to right to know law FOIA requests truly is to be brave enough to write one sentence, to put your request in one sentence, and to spend 5 hours, if it takes 5, to really articulate what you want. When I was in Chicago, I had a reporter at the Chicago Sun-Times tell me that he had asked for 2 years worth of records between 10 different people. And I said to him, I was at the Attorney General's office, I said to him, what is it that you really want? And he said, well, I really want emails that fall between December 4th and December 10th between 2 people. And I said, so why are you putting 2 years around this? And he said, well, I don't want them to know what I'm looking for. Well, let me assure you, having been on the government side of it, They know what you're looking for, okay? And so what you have to remember is it's not the public officials that are making these decisions about whether the request is going to be public most times. It's the lawyers. And I think you guys will agree, the more words you give a lawyer, the worse off you are, right? And so the first thing to do is to write a one-sentence request, or to be able to articulate what it is that you truly want before you try to put it on paper. The second thing is, and we see this in forums all over, is people say, I'm a journalist, I want the fees waived. You should never put that in a request. And here's why. Because inside the government, and believe me, I've clerked at the White House, I've worked at the Attorney General's office in Illinois, I can tell you what the government does. That means it goes through 2 layers of approval. And what you want to know is, do they have the records and can I get it? Figure the money out later, right? And now, unless the law says that you have to ask for that up front, which some laws do, you just have to be, instead of wrestling it out later like we did in the case with the pornography records, the first step is to sit down and say to yourself, what do I really want? And try to articulate it in a way that you can put into 1 or 2 sentences max. Get rid of this, that you're asking for the waiving of the copy fee. And the other piece is, think about where to go for the records other than the agency that you're going to write about. You use the ESPN example. ESPN came to us at the Office of Open Records and said they wanted to get records related to the Jerry Sandusky child rape scandal at Penn State. Now, unfortunately, Penn State is one of only 3 states in the nation where their public university is not subject to the State Freedom of Information Act, the other dubious states being Alaska and Delaware. But what we said to ESPN is, look, where else might you be able to get information about this? And we suggested that they file right-to-know law requests with the Department of Health to see what state contracts were given. So, and what turned up from that was that's how Second Mile came to be known, the charity that was sort of the pipeline for these boys. So you can use form requests, but I wouldn't. And also, keep the request as tight as you can, 1 or 2 sentences. Get rid of the request for public, for the waiver of fees. And don't put anything else in the request. Like, don't put the law, don't remind them what the law is. You can do that on appeal. But the more, and so what we found at Mutchler Lyons is we've averaged about 35 days for obtaining records for people. But it's solely based on the way the request was written. And I'm sure in your litigation you have other thoughts that work. It doesn't work all the time, in all the places, but 90% of the time it does.
I think there's a question.
Yes. During Sunshine Week, there was a program with the National Archives where the Chief Judge of the District of Columbia Federal Court, Judge Howell, talked about the growing number of cases filed at the federal level, and she said she welcomes that as an illustration that the law is working. A lot of federal FOIA litigators have found let's say, FOIA fatigue set in on federal judges. They owe government on the FOIA case. So this question has 2 parts. One is to give Judge Ho an opportunity to share any observations you may have in terms of, whether you or your colleagues like the idea of having to sink your teeth into a good FOIA case, or whether this fatigue seems to be setting in where, it's just too much, we don't like to look at the documents in camera, and we don't like, we want to get through this case as quick as possible. And then what's going on at the state level? You find that judges, they're interesting cases for the most part, so perhaps judges who spend a lot of time with the front-of-the-mind picture of commercial cases would enjoy FOIA litigation, but maybe not. So I'd be curious about your observations on that subject.
Well, perhaps it's because I'm not a DC-based judge and the target of all the federal litigation you're talking about, but I've never seen a FOIA case today, so I don't have that fatigue. Maybe ask me in 5 years, and maybe the numbers will be different then.
I don't know if it's fatigue in Texas or just general hostility, because as I outlined, we've had so many bad Public Information Act rulings. And part of it is, as Terry talked about, you've got to get the language right in the legislation. And if the things like this custodian loophole, that's a problem with the way in which the law was written. Similarly, the Open Meetings Act was declared unconstitutionally vague. That's a problem with how the law was written. And so we're finding more and more judicial decisions that are critical of how the law is written. So you have to be real careful on the front end. And I'll tell you one thing just to tag on to what Frank was talking about with regard to law enforcement. Another example of how the law was written in a way where you don't anticipate the result. But we have an issue here in Texas where if a criminal suspect was not convicted or did not receive deferred adjudication, you can't access that information. Now, logically, you think, okay, that's because somebody who hasn't been convicted, you don't want them to be exposed to, inappropriate prejudice as a result of these documents coming out. But what about the criminal suspect who died in custody? That person was not convicted. They didn't get deferred adjudication. And yet law enforcement can say, under the law, the way it was written, we don't have to give you this information. And so this also goes back to having compelling stories, and having compelling stories to be able to tell lawmakers when you're trying to get reform. We have a bill, HB 417, that's being carried by Speaker Pro Tem Joe Moody, that will address that problem. And the compelling testimony is from families of victims who have died in law enforcement custody, coming forward and telling their story about not being able to get the closure that they need because they can't access the information about how their child died. And there's a family here, Mesquite, Texas, Graham Dyer's family, who has been absolutely devoted to seeing this law change. And they have come last session and they've come this session to tell their story. And what's interesting about that is where the Texas law failed them, the federal law helped them. So they couldn't get the information under the Texas law. They filed a civil rights complaint. They couldn't get the information that way. Their civil rights complaint got poured out because they didn't have the evidence that they needed. And under FOIA, they asked the FBI why these Mesquite police officers were not being convicted. What was the analysis that went into that decision? And literally years later, they received videotapes in the mail that showed their son's last few hours getting tased mercilessly by the police, where the policeman really said, "I'm going to kill you, MF." It is all on video. There's a reason the Mesquite Police Department didn't give up those records. And it's not because the Texas law is written poorly. So that's the sort of compelling story that lawmakers need to hear. And that is where we need to fix the drafting and the very careful wording of our laws, because that is an unintended consequence that was not thought of by the lawmakers when they originally passed that law.
I see Dan has the hook here, but if I could take 30 seconds to amplify on that, because I really should have flagged this at the outset. I mean, if I had to flag one dangerous trend for you all in the states to keep an eye on, it's just exactly what Laura has identified here in Texas. There is a national movement afoot, and what makes it so dangerous is it's being done by very good people with very good intentions. But to give everybody a fresh start on their reputation by purging criminal cases that don't result in a conviction. And I will tell you the kind of journalism that's going to become impossible if this takes hold around the country. Last fall, the Minneapolis Star-Tribune did a 5-part series about rape in Minneapolis, and they were able to assess the performance of the police and the district attorney there, looking at the payoff line to this 5-part series was that in only 50% of the cases in which the police arrested somebody for rape did the district attorney's office go forward and actually take the case to court. So in half of the cases Something was going wrong between arrest and decision to prosecute. And that either signifies to you that the DA is too gun-shy about prosecuting cases, or that the police are making bad rape arrests, right? And that the DA looks at it and says, this ain't a good arrest. Either of those things is essential for the public to know about. If we close those files, we won't find that out. And so while I'm completely sympathetic to the social justice-minded folks who want to give a reputational reboot to those people wrongfully arrested for something, there's got to be a better instrument than the blunt instrument that's being circulated now around the states, which is to make these cases disappear.
Thank you, Frank. Any comments? Are we good? All right. Thank you, Frank. Thank you, Laura.